fourth and final set of slides for media law. And this set of slides is just going to be the first half, which covers access in terms of to the court and to public records. So starting off with the courts, one of the things to keep in mind is that the First Amendment, and this is kind of true for both actually courts and public documents, the First Amendment protects the press's ability to publish information. But there's no special First Amendment rights with regards to gathering information. And so that's going to be kind of the big thing, is that the press has the exact same rights to information as everybody else does. So journalists and the judiciary, the relationship between them was spelled out in 1980 with the case Richmond Newspapers versus the state of Virginia, which basically showed that there is a generally presumed right to have access to a trial. So that basically trials should only be closed from the press and from the public for very special circumstances. And remember, there's always, whenever you're closing the press out, you are always closing the public out. As long as the public has access, the press has access. Basically, the ruling principle that the Supreme Court looked at was whether or not access to trials was important for self-governing function of our democracy, and would the ability to have access to trials kind of further the democratic process. Now, this goes back to the beginning of this chapter where we talked about the reasons for a free press. The fact that in order to have proper self-governance, in order for democracy to work properly, we need to have access to information. So would access to the courts help this? Because basically it kind of always goes back to that. And the courts found that yes, in fact, it is necessary for us to have access to the courts in order to have faith in them and to ensure fair proceedings within kind of court proceedings. One of the justices, Chief Justice at the time, Justice Barger, said, "People in an open society do not demand infallibility from their institutions," in this case the institution being the court system, "but it is difficult for them to accept what they are prohibited from observing." So this kind of sums up why in the ruling for Richmond Newspapers versus the state of Virginia, the court ruled that the press and the public should not be barred from attending court hearings, and that basically there need to be very specific reasons for people to not be allowed in. Now, why would you ever bar the press? Well, the First Amendment right could, in fact, impact another amendment right, which is the Sixth Amendment, your right to a speedy and impartial trial. The Sixth Amendment guarantees, quote, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state or district wherein the crime shall have been committed." So there have been a number of cases and a number of times when the Supreme Court has tried to kind of strike that balance between the public's right to know and the public's right to have information on these criminal proceedings, and the accused, the assumption of innocence and the accused rights to a speedy and specifically impartial trial. So there's two cases your book talks about, Shepard versus Maxwell, and that kind of focuses on publicity, both pre-trial and during the trial. And then the Nebraska Press Association versus Stewart, which again is looking at kind of setting out some guidelines for what we can do to help protect Sixth Amendment rights that don't impinge on First Amendment rights. Now, Shepard versus Maxwell, some of you may be aware of the television show and the movie that had Harrison Ford that was based on Dr. Sham Shepard called The Fugitive. And basically, with this Sam Shepard trial, he was a prominent osteopath in his community. His wife was found murdered, and there was an entire media circus that surrounded him. There was an autopsy of his wife that was shown live on TV. The prosecutor was running for public office. There was all this stuff that kind of just, it created bedlam in the courtroom, both before, during, and in fact after the trial as well. The jurors weren't sequestered. The jurors became celebrities in their own right. And basically, by the time it wended its way through the court system and made its way to the Supreme Court was like, this is ridiculous. He clearly didn't have access to a fair and impartial trial. You need to have a retrial. And he, in the retrial, was found not guilty. So the court summarized its decision, ordering a new trial, saying that bedlam reigned in the courthouse during the trial, and newsmen took over practically the entire courtroom, hounding most of the participants in the trial, especially Shepard. And then about 10 years later, there was another case that came before the Supreme Court revolving around access to trials. And basically, the Supreme Court laid down some measures that courts should take before they get to the point of banning journalists, the public, cameras, etc. from the courtroom. The judge can discourage cover of the trial by what the judge says about the trial ahead of time. The judge can, in fact, discourage attorneys from commenting on the trial, which reduces pretrial publicity, which reduces the risk of having negative pretrial publicity and for having a hard time selecting impartial jurors. The judge can move the trial to a different jurisdiction. While the Sixth Amendment does ensure the right that you are tried in the state or jurisdiction that the crime occurred, there are special circumstances in which it can be moved. And for example, if you can't have an impartial jury, that's a really good reason to move a trial. You can also have there's a legal term for basically your screening, the people who are going to be jurors, to make sure that you have an impartial group of jurors. And this happens most of the time, where they're going to ask a few questions and, they're going to see whether or not people would be for or against both the defense and the prosecution. And the judge can, of course, sequester the jurors so that way they do not have access to the publicity that's going on. They don't have access to the outside world. And this is what happened in the case of O.J. Simpson. So the Supreme Court's kind of laid out some ways to try to balance the journalist's First Amendment freedoms to have access to this stuff with the fact that as citizens we have rights to a fair trial. Now, as well as access to the courts, this is kind of access to the courts is basically one kind of public record. So we also, while we have rights to publish public records, there's no First Amendment right to access public records. There's no special rights for getting access to documents. There are a whole ton of different statutes means laws, that govern our rights to access various documents at both the federal, state, local levels. There are some websites that you can access that can help you if you are interested in getting a hold of information and documents. Places like Freedom Forum Institute, and that has tons of really good resources about specifically the Freedom of Information Act, but First Amendment in general in all of its forms. As I remind you, the First Amendment actually confers 5 different rights. And then there are state statutes which govern states, obviously. Then you also have county and municipal statutes. The National Freedom of Information Coalition, NFOIC, has a great state-by-state guide where you can click on a state and it will show you all of the states' open meeting laws and public record laws, and actually will give you a template for how to file a Freedom of Information Act request. So there are lots of resources to help you, but it can be a really arcane and frustrating kind of journey to try to access some of these documents. Now, each federal, state, local law will spell out things like what do they refer to in terms of public records. Like, for example, New Hampshire has like a open record law which kind of combines meetings and public records together. Most states separate those out into 2 different laws. What's the process for getting public records? What can you not access? And if you are denied because they say it's off limits, then is there a way to appeal that decision to like a higher body? And in fact, more and more you do run into denial of access, and there's straight out denial of access, and then there are other ways that the government can limit our access without actually having to deny anyone's particular request. So the most common denials, especially at the federal level, for the Federal Freedom of Information Act requests, are for national security and for privacy. National security being the number one. It's interesting because President Barack Obama was very much, saying, I want to be open and transparent, but in fact, there were more denials of Freedom of Information Act requests under his government than any other prior. So you've also got states which are going to access restrict access to government records, and states can deny access based on federal national security grounds. So you might ask something about the police force in your state, but be told, well, that actually pertains to national security, and so we can't give you that information. And it's very hard to tell whether or not something actually impacts national security without seeing the document. So it's very easy as a way of rebuking people. Increasingly, more and more, we have privacy as being a grounds for withholding documents, especially, as there's more and more concern about privacy in general. Of course, you could get redacted documents where things are blacked out, but again, how good is a document in which half of it is missing? And there's other ways that we can kind of restrict access that isn't technically denying access, but that makes it so that people still can't get access. For example, there can be very high fees involved for requesting information. Freedom of information does not mean that it is actually free for you to access. In fact, a lot of these cost money. Theoretically, it's for administrative purposes, but it's also there to dissuade people from filing these requests. And there is no special, you don't get a discount for being a journalist. Also, government agencies don't have to fulfill your requests in any particular time frame. There are, in fact, freedom of information requests that have been filed that date back decades that haven't been denied, but they haven't been fulfilled either. So you might as well have denied it, but they're just sitting there and no one's doing anything about it, and they're just being stonewalled. To fight back, journalists have tried to do public shaming, find ways of basically saying, highlighting areas where people are not being open. So the Society of Investigative Reporters and Editors, the place that I sent you to for, one of the places I sent you to along with the Pulitzer website for finding pieces about investigative journalism, has a Golden Padlock Award that they give out every year to the government agency that kind of obscures itself the most, that locks people out the most. And in fact, our good old Boston police won it a few years back. So, they shame on all levels of government. So that's how basically people try to combat it. But really, it's very hard, unless you're going to have something that's going to go all the way to the Supreme Court, for you to actually fight back if someone doesn't want to fulfill your request. So how do you successfully kind of request a public record? How do you successfully get your hands on it? Well, first and foremost, you need to know the laws that kind of govern the jurisdiction you're interested in. A lot of times, talking to people is a great way to get started before you just file a request. It kind of goes back to when we were talking about being on a beat, and we had that reporter who went in and started kind of asking about very generic stuff, and then he was building up a file, and basically by the time they figured out what he was building up, they realized that they couldn't stop him. And so, try to find ways to access things without setting off alarms. If you just file a Freedom of Information Act request, that's going to set off alarm bells. So if there's a way for you to get it, and try to kind of, work softer channels first, that might lead you to more success. But also know that if you are granted a request, if they give it to you in a format which is unintelligible, you can go back to them and say, no, I need this in a format that is workable for me, that is viewable for me, that is legible, and you are entitled to that, and they can't say, oh, well, now we're going to deny you. Know what you're looking for. If you can be very specific about what you're looking for, one, you're more likely to get a yes because it's easier for people to find that. Two, again, you might be less likely to set off alarm bells, especially if what you're starting with is innocuous. And then, once people work out what you're tying together, it's kind of too late. But you have to be resilient, and you're going to probably have to go back and ask multiple times in order to get what you're looking for. Now, when you do get what you're looking for, you still need to be very transparent when you report what you've gotten from government records. For two reasons. One, you need to cite your sources so that people know knows where it comes from. But two, people need to understand the context of what they're looking at. And sometimes that means understanding that this might not be the whole picture because of the, this is what I've been given access to because this is what the government's willing to release. Or perhaps it's maybe particularly valuable because of the fact this is coming from the government and that it's official. So make sure that you're very clear where you're getting that information from. In the next section, speaking of citing sources, we're going to talk about copyright.